the previous videos, we mentioned about damages for non-completions. This happens when the contractor is unable to complete the work before the dates of completions as agreed in the contract. As a result of these non-completions, liquidated damages will incur onto the contractor. It is a penalty for the non-completions. The rate will be calculated by the numbers of the days of delay. The longer the project delay, the heavier the penalties imposed onto the contractors. With that, by all means, the contractor would like to avoid this liquidated damage. In the case of the delay of the project, contractor will typically seek for the possibility for the extensions of time, as this extension of time will shift forward the completion date and revoke the status of the project due to the non-completions. This is going to revise the liquidated damage imposed onto the contractor. In order to avoid the contractors to abuse this extension of time, there are conditions. This will be discussed in these videos regarding Clause 23, extension of time. You may refer to the PAM contract 2018 for the full statements of the clause under the extension of time. This section is quite long. It comprises 10 sub-clauses, as it provides a lot of important informations under the extensions of time. For easy understanding, we simplified the informations in the slides. First, we talk about the submissions of notice and particular for the extension of time. For your informations, the short form for extension of time is EOT. Now, in the case there will be delay of the completions of the work, the contractor may apply for an EOT, provided that the contractor will need to submit a written notice to the architect. The notice shows the intentions of the contractor to claim for the EOT. The contractor will need to provide initial estimate in terms of the durations to be extended, and there should be supporting particular for the cause of the delay. That means the contractor will need to justify the relevant delay is not due to the negligence or omissions of the contractor. There should be reasonable reasons that the contractor is entitled for the EOT. This is subjected to the entitlement of the EOT for the contractor. Now, when this written notice should be submitted to the architect, it is stated that within 28 days from the date of the architect instructions or confirmations of architect instruction, or within 28 days upon the commencement of the relevant event, whichever is earlier. You know that by fundamental, EOT may be granted when there are unforeseen circumstances beyond the control of the contractor, and it is not due to the fault of the contractor. PAM contract do list out the relevant events that could be considered for the extension of time. There is quite a lengthy list of the event which the contractor is entitled for the extension of time. We shall look into this event later. Now, this written notice needs to be submitted to the architect soon as possible to show the intentions to claim for the EOT, to give the architect an idea about the durations of the extension estimated, and also to justify the cause of the delay is not actually due to the problem of the contractor. If we look at the clause here, it seems that the architect has the right not to entertain for this EOT after 28 days of any of these two. With that, as a contractor, you will need to be very diligent to prevent yourself from getting this liquidated damage imposed onto you. This will be the first stage of applications for the extension of time. The purpose here is to show intentions to claim for the extension of time, as well as allowing the architect to consider regarding the entitlement of this extension of time. When it comes to the final claim of this extension of time, the contractor will need to submit the claim within 28 days of the end of the cause of the delay. The contractor will need to submit the claim for the EOT plus the supporting particular to prove this cause of delay is actually not due to the problem of the contractor. The architect will do the assessment whether the EOT is granted. If the EOT is granted, that means there shouldn't be any liquidated damage imposed onto the contractor. However, if the extension of time is not granted, upon exceeding the completion date, it will be considered as non-completions, and this shall trigger the liquidated damage. Next is about the insufficient informations. Indicates that the particulars submitted by the contractor are insufficient. Within 28 days from the receipt of the contractor's particular, the architect will need to write to inform any deficiency and request for further particular within the next 28 days. That means there is a chance given to the contractor to further submit the informations for the applications of the EOT. Once all the particulars are sufficient, the architect will need to decide whether to grant the EOT or to reject the EOT. In the case that the EOT applications is rejected, the architect will need to issue the written notice of rejections. In the case that the applications of EOT is accepted, the certificate of extension of time will be issued within 6 weeks from the receipt of the sufficient particular, before or after the completion date. That means with the applications of this extension of time by the contractor, when the particular given is sufficient for the architect to make decisions, if it is accepted, within 6 weeks, the certificate of extension of time will be issued. There are other considerations for this extension of time. First is about the new completion date. Sometimes this EOT is submitted before the completion date, especially upon occurrence of the relevant event that are entitled for EOT, and the contractor can foresee that due to this relevant event, the project would delay. Based on the requirement as per stated here, when the relevant event occurs, the contractor will need to respond quickly and apply for the EOT. Exceeding 28 days, the applications of EOT will not be entertained. So now with the applications of EOT and the EOT is granted, theoretically the new completion date should not be earlier than what is stated in the appendix. This is not logical. EOT is granted so that the new completion date will be later than the original. It shouldn't end up to be earlier. And in case that there are omissions of certain words under the contract, By right, the durations of words would be shorter, but this shall not revise the original completion date. In another word, the new completion date after the EOE should not be earlier than what is originally stated in the appendix. Another thing is, the architect will need to consider if there is any other relevant event which will affect the contractor's entitlement to EOT. The architect will need to be diligent to know whether the contractor is actually taking advantage or abuse the EOT facilities. Next, the contractor should be to his best effort to prevent or to reduce the delay in the progressions of the work. Even though the EOT is granted, that would be the worst case scenario to the employer. Preferably, the contractor should try his best in order to minimize the delay and not to use up the entire durations of the EOT. This will be a big favor to the employer given by the contractor. Next, the architect should notify all the NSC. NSC stands for the nominated subcontractor after granting the EOT to the contractor. It is so that all the NSC is aware of the new completion date, so that they can abide with the completion date. Just now we mentioned about the relevant event entitled for the extension of time. There is a full list of those events here. They are also listed here. Continue from this previous slide. In the case that you would like to apply for EOT, probably you will need to read between the lines whether the cause of the delay are related to any of these events. In general, these events happens beyond the control of the contractor. It is not due to the problem of the contractor. Even the contractor wished so badly to complete the project on time. Because of this relevant event, the delay inevitably happens. We have force majeure. This is referring to any circumstances beyond the control of the contractor caused by the terrorist acts, governmental or regulations actions, epidemics, and natural disasters. It could be due to the weather or due to the loss or damage related to the contractor or risk insurance, which is not due to the negligence. The relevant case related to the contractor or risk insurance are listed here. You may refer to clause 20. It could be due to some political instability, such as civil commotions, strike or lockout. It could also due to the delay of the architect instructions, that the problem caused by the architect, even though the contractor has tried his best to pursue the instructions of the architect through written requests, and yet the architect instructions still delay, and this significantly affect the work progress. The contractor is entitled for the extension of time. There are other modes. The contractor will need to prove that he is eager to complete the work on time and it is not his fault leads to the delay of the work, so that he is entitled for the extension of time. Next is extension of time after the issuance of certificate of non-completions. Within 12 weeks after the date of practical completions, architect may review the EOT and further postponements of the completion date if necessary. This 12 weeks is equivalent to 3 months, which is equals to the period of delay. The architect will need to review whether the extension of time should be given to the contractor. This shall be final review to the contractor. Now the durations of the new extension of time should be greater than what was granted previously. It should not be less than the initially granted. That's why the statement says here, further postponements of the completion date if necessary. What has agreed to be granted to the contractor cannot be revised. If there is a valid reason, additional durations may be granted as the new EOT. Now the completion dates will affect the amount of liquidated damage by the employer, and the employer may retain the payment as per the amount of the liquidated damage which he entitled of. The surplus amount should be repaid to the contractor within the period of honoring certificate. In another word, when liquidated damage incurred to the contractor, the employer has the right to retain the said amount of the liquidated damage from the payments to the contractor. The balance of the amount shall be repaid to the contractor, and this must be paid within the period of honoring certificate. There is a period that the claim must be paid to the contractor, and this period is known as the period of honoring certificates.